that the stay was finally lifted. Accordingly, we accept the position that Judge Tunoi attained the age of 70 years on 2nd June 2014, which was not denied by the judge. As a consequence, he no longer is a serving judge. As there is no person before it, there is no point in this tribunal investigating further his conduct, and the proceedings before the tribunal must necessarily come to an end. We can find no provision in the Constitution to support the tribunal proceeding with further hearing as regards the now retired judge. Even the provisions of the 6th schedule, transitional and consequential provisions, are silent in respect thereto. Further, Section 31 of the Judicial Service Act, Cap 185B, and the 2nd schedule thereto make no reference to tribunals continuing in their investigation into the conduct of retired judges. Accordingly, we adopt the observations of Lady Justice Lengalenga in the Dr. Philip Musonda case. Where would the tribunal derive its authority to proceed its hearing against the applicant as a non-judicial officer? As there is no provision of law to support the tribunal's decision to proceed with the hearing against the applicant, I am inclined to accept that the tribunal's decision to proceed against the applicant without provisions of law to support such decision is illegal, and I do so accept it. However, the tribunal in this instance does not intend to decide one way or another whether, in the circumstances of the matter, it is functus officio or not, but to report on the facts to His Excellency the President on the status of the evidence now before it. The general public interest in the administration of justice requires this. The fundamental role played by judges in the judicial system is emphasized and well brought out in the Canadian case of Judge Therrien versus the Minister of Justice and Attorney General of Quebec, Attorney General for Ontario, Attorney General for New Brunswick, and it is quoted in 84 CRR 2D1, where the court found as follows. Accordingly, the personal qualities, conduct and image that a judge projects affect those of the judicial system as a whole, and therefore the confidence that the public places in it. Maintaining confidence on the part of the public in its justice system ensures its effectiveness and proper functioning. But beyond that, public confidence promotes the general welfare and social peace by maintaining the rule of law, and in a paper written for its members, the Canadian Judicial Council explains, public confidence in and respect for the judiciary are essential to an effective judicial system and ultimately to democracy founded on the rule of law. Many factors, including unfair or uninformed criticism or simple misunderstanding of the judicial role, can adversely influence public confidence in and respect for the judiciary. Another factor which is capable of undermining public respect and confidence is any conduct of judges in and out of court demonstrating a lack of integrity. Judges should therefore strive to conduct themselves in a way that will sustain and contribute to public respect and confidence in their integrity, impartiality, and good judgment. Factual findings in the report that the tribunal will present to His Excellency the President will focus on the evidence before the tribunal, but make no findings on the matter before it, because the inquiry is not complete. The tribunal has yet to hear additional witnesses, recall Jeffrey Kiplagat to respond to the contradictions that are surfaced on his evidence from the evidence which followed, and is yet to hear the judge himself, that is, if he was minded to give evidence before the tribunal. The tribunal is of the view that it is now not necessary and will not serve any useful purpose, as the judge has been retired and is no longer a judge in whose respect the tribunal could make any binding recommendations to His Excellency for his removal or otherwise. For the avoidance of doubt, the tribunal clarifies that it will not inquire into the allegations any further, and effectively this brings to a stop the matter before it, save and except that it will report to His Excellency the President the evidence brought before it to date. That is the ruling dated today, the 27th of June, and signed by all members of the tribunal.
Thank you very much, Mr. Chairman.
Now, is there anything that you would want to say? And we will ask Mr. Ngatia the same question.
No, Mr. Chairman, there is nothing I wish to add. We have listened to the ruling, and we have heard the tribunal's decision, and the tribunal, having held that its life, its proceedings have come to an end, I believe that is then it, Mr. Chairman.
Not that it has come to an end. We are bringing it to an end by saying it does not serve any necessary purpose. Yeah? Mr. Ngatia.
We followed the decision as much as we could. Of course, not having been privy to the decision, we are trying to follow it and making notes. I think, in all fairness, there ought to be an opportunity for us to comment on the evidence. That opportunity should be given to us to comment on the evidence already recorded. I think I heard you saying, Mr. Chairman, on functions 1 and 2, you want to complete it fairly and truthfully. It's on number 3, recommendation about retention or removal, that you can't handle, for which I agree entirely. So give us an opportunity to comment on the evidence already on record, because that is an important part of the report to the appointing authority.
Where could you do this in, say, the next half hour, or after the next half hour, after you've studied the ruling, and then you can address us on it? I don't think whether the council would want to address, but after listening to you, he may want to comment. Yeah.
I would rather he made an election now, whether he would want to, so that we agree on a time period.
Would you be ready in half an hour, you think? What you could do is to address us briefly, if you wish, and then put in written, a fuller written report on what you want us to consider as wanting to report to the President. We will be quite amenable to that.
As a matter of fact, the way we have been journeying together, we don't want to do any written submissions. We want the Kenyan people to follow us as we go on.
That's fine.
So I'll prefer that I do everything already and publicly.
Fine. But we would like you to do it today, because we want to finish with the proceedings today. So we could give you, and you have known that at some stage you will be asked to make your submissions, so you had the time. You're fully familiar with the facts of the case.
Yes.
So we would say, what is the time now? It's 12:30?